question number 1. The adjudicating authority appointed under the Prevention of Money Laundering Act 2002 issued an order attaching certain properties XYZ Limited alleged to be involved in money laundering for a specified period. The company, agreed by the order of the adjudicating authority, seeks your advice about the remedy that is available under the Act. Analyze and apply the relevant provisions of the Prevention of Money Laundering Act 2002 in relation to the above situation. This is question number 1, sub-question. Sohan Lal, a farmer, was found involved in embezzlement of opium cultivated by him. State the punishment that can be awarded to him under the Prevention of Money Laundering Act. There are 2 questions here. The first question is about the attachment. Now, when you want to answer the question, first of all, you should remember if at all possible, always remember the section 25, for example. The relevant section will be 25 and 26. What section 25 says? So, section 25 says that the central government established a tribunal called Appellate Tribunal to hear appeals against the order of the adjudicating authority and other authorities under the Act. Here what happened? The adjudicating authority issued an order here. Therefore, the person who agreed with the order of the adjudicating authority, what is the remedy open to him? Normally, this kind of remedy by way of appeal. Where to file, how to file, when to file, these are all the things we'll have to discuss. Therefore, first of all, you see, section 25 of the Prevention of Money Laundering Act empowers the central government to establish appellate tribunal to hear appeals against the order of the adjudicating authority and other authorities under this Act. So, appellate tribunal, the very term indicate it is the appellate authority. Appellate means file an appeal. So, section 26 deals with the right and time frame to make an appeal before the appellate tribunal. So, any person agreed by the decision of the adjudicating authority, he may file an appeal within 45 days from the date on which he received the copy of the order of the appellate authority. So, whenever an appeal is filed, there is a prescribed format in which it has to be filed and some fees to be paid, prescribed fees to be paid, and 45 days is the time given. Yes, suppose the appeal is filed after 45 days, whether it can be entertained. That's a big question. And here it has been specifically provided, yes, the appeal can be entertained even after filing, even after lapse of 45 days, provided sufficient cause was given. The maximum period, not filing an appeal within 45 days, the maximum period is over. Suppose the agreed party is able to convince the appellate authority for the reason for not filing an appeal within 45 days, then appellate authority may condone the delay and admit the appeal. This is actually, there is a provision in this connection. I would like to inform you that there is a provision in the Limitation Act. Limitation provides for that. That is, that this kind of condemnation delay in filing an appeal is permitted only in the case of appeal, not in the original suit. It is only an appeal. So their limitation, what they say, they evolved a doctrine called the doctrine of sufficient cause. So if your appellant is able to satisfy the appellate tribunal, appellant is able to satisfy the tribunal, why he is not able to file an appeal within the prescribed period of 45 days, and every day of delay should be explained to the satisfactory tribunal, then tribunal may admit the appeal, if the tribunal so satisfied. This is one thing. Then, after admitting the appeal, the tribunal may issue notice to the parties concerned. After giving a reasonable opportunity of being heard to all the parties, tribunal may pass an appropriate order. Maybe it may be confirmed, it may even confirm the order of the adjudicating authority, or it may even set aside the order of the adjudicating authority, or it can even modify the order. Therefore, whatever the order appellate authority makes, that is normally acceptable. But the party who is not happy with the order of the appellate authority, he has another opportunity to file an appeal. That appeal lies in High Court. Order of the appellate authority can be filed before the High Court. There, the time limit for filing the appeal in the High Court is 60 days. Suppose even there, that 60 days from the date on which they got the order of the appellate tribunal. Suppose there is a delay in filing an appeal even before the High Court, then High Court may, if it is satisfied that the person filing an appeal is prevented by sufficient cause from filing an appeal within the set period of 60 days, then High Court is also empowered to admit the appeal by condoning the delay, but not exceeding 60 days. That means High Court may give further time for 60 days. This is given in section 42 of the Money Laundering Act. Therefore, a person who is grieved, who is aggrieved by the order of the adjudicating authority, he may file an appeal before the appellate tribunal. So that is the appeal provisions is there. So the advice may be given to the person concerned for the provisions contained in section 26 for filing an appeal, etc. XYZ limited may be appropriately advice for filing an appeal. This could be the answer. While giving the answer, it is always better to pinpoint the section number and also the provisions. It is not necessary you should exactly repeat the same verbatim, but it is advisable to use as many words as possible, technical words used in section, while you are giving your answer to the questions. Then, coming to the first part of the question we answered. The second part is Sohanlal, a farmer, was found involved in embezzlement of opium cultivated by him. Then what is the punishment for that kind of thing? Here, when you talk about the punishment for the money laundering offences, section 4 is relevant. Section 4 is relevant. As per section 4, a person who commits the offence of money laundering is punishable with rigorous imprisonment. Normally, it is for a period of 3 years to 7 years. 3 years minimum and 7 years maximum. And besides the imprisonment, fine will also be levied. But wherever the process of crime involving money laundering relate to any offence specified in para 2 part A of the schedule. Para 2 part A deals with some, for example, Narcotic Drugs and Psychotherapeutic Substances Act. This is one thing. There, the maximum punishment, minimum is 3 years only punishment. Maximum punishment is 10 years. 10 years. Therefore, this is the embezzlement of opium by the cultivator. It is covered under this paragraph. This paragraph, that is the paragraph 2 of part A of the schedule. Therefore, Sohan Lal was involved in embezzlement of opium cultivator. There is liable for punishment, for maximum punishment for him will be 10 years. So whatever we say, in fact I pointed out, you can see here also, section 4 of the Money Laundering Act provides for punishment of money laundering. Therefore, the person who commits any offence of money laundering is punishable depending upon the nature of the offence. If the offence is covered under paragraph 1, then punishment is minimum 3 years, maximum 7 years. If it is specified in paragraph 2 of part A, the minimum punishment is 3 years, maximum will be 10 years. Instead of 7 years, it is 10 years. Therefore, and when you talk about that, as I pointed out, this is coming under this category. Ken Sohan Lal, a farmer, was involved in embezzlement of opium cultivated by him. is liable for rigorous imprisonment. It is left to the discretion of the court. They may go up to 10 years also, maximum period of 10 years. In addition to the fine, that whatever the amount the court may fine, appropriate. This is the first question. Let us move on to the second question. It involved purchase of flat by B. Mr. B purchased a flat out of the proceeds earned by drug trafficking. The flat was attached by the director, Enforcement Directorate, after complying with the procedure under Section 5 of the Prevention of Money Laundering Act. Mr. B got a stay from the High Court for the proceedings under the said Act. The stay was subsequently vacated. Stay the provisions of Money Laundering Act for computing the period of provisional attachment, including extension, if any. So that is the second thing. Whether Mr. C, son of B, can occupy the flat during the period of provisional attachment. This is the question. Now, what shall be the answer for this question? That is the second question. What should be the answer? Then let us look at the answer for this particular question. Just 1 minute. When you talk about the answer for this particular question, I was giving a brief about the PMLA Act, that is Money Laundering Act. I was telling, one is the attachment, the second is the adjudication, and third one is what you call the confiscation. Okay. Now, when you talk about this act, you find Section 5 is the relevant. What Section 5 says? The director or any officer who has been authorized, normally an officer not below the rank of deputy director, enforcement director, you got a deputy director level minimum, he will be authorized. So when he was authorized to deal with the cases, investigate the cases, during the course of investigation, if the investigating officer has reason to believe, but reasons to believe mean he must record his reasons in writing. He reasons to believe that on the basis of the material in his possession, that any person who is in possession of proceeds of crime, any person who is in possession of proceeds of crime, and that proceeds of crime will likely to be cancelled, concealed, transferred, dealt with any manner, which may result in frustrating the entire proceeding itself, then he may, by an order in writing, provisionally attach the property. The provisional attachment will be for a period of 180 days. 180 days. Therefore, the property can be attached. Now, what happened? While computing the provisional attachment, the stay which has been, because in this case what happened, the B got stay from the High Court when the proceedings of the Act. So the stay was in period for some time, and the Enforcement Directorate might have applied for vacation of stay, and the stay was also vacated as per the facts of the case. Stay was also vacated. Therefore, the period during which the stay was there, the property not money laundering, during with the period for computing the period of attachment, the purpose of computing the period during which the proceedings were stayed by the High Court shall be excluded. So for the 180 days plus stay period, then further period, that is 30 days from the date of the order of vacation. Once the stay is vacated, then another 30 days. So the question is, what are the provisions of Money Laundering Act for computing the period of provisional attachment, including extension. So this period should be excluded. Fine. The period of stay should be excluded and 30 days should be excluded. Fine. Now, question is, Mr. B is there, his son is there, C. Whether son can occupy the flat when the proceedings are under attachment, the property is an attachment, can the son of the accused can occupy the property? That is the other question. For that, the answer is simple. The attachment of the property does not affect the right to enjoy the property. This section shall not prevent the person interested in enjoyment of immovable property attached from his enjoyment. That is subsection 4 of section 5. Let me be very clear. Subsection 4 of section 5 makes it very, very clear that nothing in this section, that is nothing in section 5, shall prevent the person interested in the enjoyment of immovable property attached, that nothing in this subsection shall prevent the person interested in the enjoyment of immovable property attached. That is, who is the person interested? The interpretation is the person interested. The person interested in relation to immovable property includes all persons claiming or entitled to claim any interest in the property. Normally, the person who owned the property and who has been tried and who under Money Laundering Act, and this property is attached, his son is C. B is the accused, C is the son of accused. The property attached, so C can occupy the property. Therefore, in the given case, C, son of B, can occupy the flat during the period of provisional attachment. Okay, if he claims to have any interest in property, obviously, son will be having an interest in father's property. Obviously, the answer will be positive. Positive. So the question, if you look at the question, there are two questions to be answered here. B purchased a flat out of the proceeds earned by the drug trafficking. That obviously it is the proceeds of crime. The flat was attached by direct enforcement director after completing the procedure. Okay. Section 5 deals with that. And B got the stay from High Court. Then the stay was subsequently vacated. Then 180 day is the period of provisional attachment. What are the things to be counted? What are the days to be not counted for attachment? They said that the period of stay during which the proceedings are stayed by the High Court, number 1, 30 days of the stay vacate, both should be excluded for the purpose of completing 180 days. That is number 1. The second question is whether the son of B can occupy the property during the period of attachment. Answer is yes, because now even though the property is provisionally attached, nothing in subsection 5 will affect the right of the person to enjoy the property. That is, subsection 4 of section 5 makes it clear. Section 5 does not have any effect of affecting the rights of the person to enjoy the property. That is the reason why you find that the son of B can enjoy the property. This is about the Money Laundering Act. So we are now going to the Foreign Contribution Regulation Act. We are going to the Foreign Contribution Regulation Act. Yeah. We now go by the Foreign Contribution Regulation Act. When you talk about this act, what is foreign contribution? What is foreign contribution? That is one thing, number 1. You must know what is foreign contribution. And the foreign contribution, to be very precise, includes donation, delivery, transfer from any foreign source. What? Any article, any currency, any donation. These are all things made by foreign source. So, second is, there are certain persons who cannot receive foreign contribution. They say government servant cannot receive. Latest amendment says public servant cannot receive. Now, I am going to give you a small tips to you. The Foreign Contribution Regulation Act was amended in the year 2020. In the year 2020. 3 major amendments are: 1, there is a centralized foreign contribution shall be, whatever received shall be remitted only to a particular bank, particular branch, that is State Bank of India, at a particular branch in Delhi, number one. Number two, whenever earlier there was a provision, foreign contribution received by an entity, there is another entity which is also which is also using foreign contribution for some specified purposes. It can unutilized the contribution, some amount it can transfer to other organization. Now the amendment says absolutely no contribution can be transferred. No person who is registered and granted certificate and who has obtained foreign prior permission, who has received the foreign contribution, no such a person can transfer the foreign contribution to any other person. This is a blanket ban imposed by 2020 amendment. Earlier it was not there. It was permissible. Now it is not there. The earlier how it was permitted, there are two things which are permitted. One is there are no restriction on transfer of fund to other organization. Now the restriction ban has been put. The third point which you should remember, which is an amendment made in 2020, is that the administrative expenses are allowed to the extent of 50% of the foreign contribution. They can adjust toward administrative expenses. Now the 50% has been reduced to 20%. That means they want to fuller utilization of foreign contribution for other purposes rather than this. Okay, that is this is all the major thing. And any organization which is registered with the Ministry of Home Affairs and or obtained a prior permission, they can only receive foreign contribution. Other people cannot do that. That means for registration there is a formality. There is a formality. What is the formality? A society, a trust, or Section 8 company. Only 3 organizations can be registered under Foreign Contribution Regulation Act for receiving foreign contribution. And they should have been existent for minimum 3 years. And they should have spent some money, at least 10 lakhs rupees in the last 3 years for the purposes. So the recipient of the foreign contribution should be an entity by way of a society, or registered under Societies Act, or a trust under Trust Act, or a licensed company under Section 8 of the Companies Act 2013, or Section 25 of the Companies Act 1956. Secondly, the company should have been existent, the entity should have been existent for a minimum period of 3 years. Third, it should have spent at least 10 lakh rupees towards the specified purpose in the last 3 years. Then only it will be eligible to receive foreign contribution. Okay. But the new entity which has not satisfied the eligibility requirement, it will not be eligible for registration. Whether some foreign donor is willing to give money to the new entity, whether it can receive and spend for the purpose. Answer is yes. For that, it has to get prior permission from the government for receiving donor, for receiving foreign contribution from a specific donor for a specific amount for a specific purpose. So that is only the requirement. So keeping all these important provisions in mind, in the light of the amendment, please read the amendment made in 2020. Keep the 2020 amendment in mind, and while answering any question on foreign contribution. That is one of the latest amendments, which is very, very relevant, very important also. Keeping this in mind, we now proceed to answer the question relating to Foreign Contribution Regulation Act. The first question is, X is an association having registration to transfer foreign contribution received by it to another organization. Is the valid act of X? Number one. If yes, then what is the process to do so? Is there any restriction on transfer of funds to other organization? Is there any restriction on transfer of funds to any other organization? So this is the thing. Is there any restriction? That is our question. How to answer this question? if you look into the old section 7, pre-amended section 7 of Foreign Contribution Regulation Act, it provided that an organization which has been registered under Foreign Contribution Act, Foreign Contribution Regulation Act, and or which has obtained prior permission under the Act, which has received the foreign contribution, it can transfer the foreign contribution to any other person, provided that other person is also registered or obtained prior permission under the Act. That was the provision earlier. And how to transfer, what is the procedure? It was there in the Rule 24, prescribed the rule, how it should be procedure, etc. Then later on, what happened? Both the entities, the transferor entity and the transferee entity, must file a return with the appropriate authority. This is the answer that should have been given at the amendment not in force. But now the position different. There is an amendment made in 2020, and where the section 7 has been completely substituted, in the sense, and the rule 24 has been omitted. That is foreign contribution regulation rules 2011, and from that rule 24 has been omitted. Why it was omitted? Consequent to the amendment made in section 7. What section 7 says? No person who is registered and granted certificate or has obtained prior permission under the Act and received foreign contribution shall transfer such a foreign contribution to any other person. That means foreign contribution cannot be transferred to any other entity, even though that entity has been registered under the Act or entity has got prior permission. Now you have to spend it by yourself. The organization which you receive the foreign then by send it to yourself. What is the purpose? Why there is an amendment? The amendment is to prevent recipient of foreign contribution mere conduits in facilitating agents for that means you cannot act as an agent for other. When you receive it, you spend it. Why do you want to transfer it to somebody else? Of course, it has got advantages, it has got disadvantages. Disadvantage, only one disadvantage we can foresee. There is a micro level agencies, a micro level organization. They take care of the society's welfare at the local level, but they may not be able to get the foreign contribution, even though they are the organization interested in doing this kind of services. They may not, but if the transfer facility withdrawn, they may suffer to a lesser extent, to that extent. But that doesn't matter. Therefore, the answer to this question now is transfer not permissible in view of the amended section 7 by the act which has been amendment act which has been passed in year 2020, and after deletion of the relevant rule, namely rule 24 from the foreign contribution regulation rules 2010. This aspect. 4. What question number 4 says? We look into that. Here there is a open university, Amal Open University of Languages, a private university established under a state act, was meant to provide degree, diploma, certificate courses to the students through online learning platform of various Indian languages. The examination was also decided to be held online through PC or laptop. Several foreign governments intend to offer donations and contributions for the development of the language. Mr. Bhupendra, the registrar, applied for registration of the university and was granted certificate to receive foreign contribution for the purpose of preparing the educational material, that is print or soft copy, paying of honorarium to the teachers, and IT-related infrastructure for online classes only. Mr. Bhupendra faced financial problems for building infrastructure of the university campus. Advised Bhupendra whether foreign contribution received for language development can be used by him for building infrastructure of the university campus. Now, whether, first of all, we have to answer this question with a reference to the relevant section. relevant section is section 8. What section 8 says? Section 8 makes it very clear that every person who is registered and granted certificate or given prior permission under the Act and also receive foreign contribution, he shall utilize the contribution, such a contribution only for the purposes for which it has been received. So, it shall not be used for any speculative purposes. But there are certain administrative expenses. Not a speculative purpose, there are certain administrative expenses. Can it not be spent for administrative expenses in a financial year? Can it be spent? So, yes, it can be spent. But is there any ceiling on spending the money for administrative purposes? Here there is a ceiling. What was the ceiling? Earlier it was 50% of the contribution received in a financial year. It shall not exceed 50% of the contribution received in a financial year. But that has been reduced to 20%. That has been reduced to 20%. Not only that has been reduced to 20% now, administrative expenses here also it can be spent. Instead of 50%, it is 20% now. The 20% has been fixed by the FECRA amendment made in the year 2020. But even for spending the 20%, they require the prior approval of central government. Prior approval of central government. So, why? Because what are the elements? Central government may prescribe certain elements which are included administrative purpose. That means you cannot say administrative purpose is a very big term. You can include any amount of administrative purpose. That is not possible. Therefore, what is administrative purpose? Central government may prescribe some rules for that. But normally what happens, let us think it over. Administrative expenses shall include salaries, remuneration, rent, utility bills like electricity, legal and professional charges. These are all coming into administrative purpose. But nowhere we find the building, construction of building comes under administration. So building infrastructure, building the building or infrastructure, etc., doesn't come under the administrative purpose. Therefore, the answer you should write is that it shall be spent only for the purpose the foreign contribution is received. The foreign contribution shall not be diverted. The end use of the funds has to be ensured. Therefore, Mr. Bhupendra, the registrar of the Amal Open University, cannot use the foreign contribution for building the infrastructure for the university campus. It is not coming under administrative expenses. So, had it been into the administrative expense, perhaps you would have spent, but not that also you take the prior permission of central government 20%. Now it is not coming in the administrative elements. Therefore, it is not possible. That could be your answer for this the question. One more question we'll discuss. This is a foreign company, XYZ Limited, was established by few Indians in South Africa. The management of the company used to donate huge amount to the religious trust in Mumbai, that is India. In the light of the foreign contribution regulation in 2010, examine whether the donation so made by XYZ Limited is a foreign contribution. Is the acceptance of such a donation by religious trust valid? Two things are there. Now, you will have to look into the relevant sections. The relevant sections are: 1. What is foreign contribution? Section 2, definitions. Go back to the definition. Foreign contribution has been defined in section 2(1)(h). Now what happened? It may be difficult for you to remember the subsection also 2(1)(h). If you write section 2 defined, because most of the act definitions are contained in section 2. Definition contain only section 2, most of the act. Only in very few act they are different. Therefore, as per the definition of a foreign contribution act, as per the definition of foreign contribution given in section 2(1)(h) of the act, foreign contribution means donation, delivery, or transfer made by any foreign source. Made by any foreign source. Of what? Of any article or any currency, whether Indian currency or foreign currency, or any security, whether Indian security or foreign security, under FEMA, Foreign Exchange Management Act, under FEMA. So this is what we call as this thing. So if you look into the definition, whether the donation, that is money given by XYZ Limited, whether donation given by XYZ Limited is a foreign contribution. Answer is yes. Obviously yes. Obviously yes. Why? Because the company is a foreign company. It's a foreign company. Because even though the Indians have gone abroad, the Indian registered a company abroad, it's a foreign company. So foreign company is a foreign source, number one. And they are giving donation. Donation comes under the definition 2(1)(h). Therefore, it is the donation which is coming from a foreign source, namely the foreign company. Therefore, it's a foreign contribution. Answer is yes. So the first answer is foreign source, as per the definition given in section 2(1)(j) of the Foreign Contribution Regulation Act, includes a foreign company. Since XYZ is a foreign company, you can call it as a foreign source. Accordingly, the donation received from XYZ shall be treated as foreign contribution. And it is given for what purpose? Religious and charitable purpose. Religious and charitable purpose. Because it is donation by a trust. Yes. So then section 11(1). Section 11. Persons having a definite cultural, economic, educational, religious, or social program. This is section 11, subsection 1 says, they shall not accept foreign contribution unless such a person obtains a certificate of registration from the central government. In the instant case, whether the trust, the religious trust in Mumbai, whether it has obtained the certificate of registration from central government or not, it is not given. It is not given. The trust would have been registered under Trust Act, that is okay. Has it been registered under the Foreign Contribution Regulation Act? It is not given. Therefore, when it is not given, we cannot assume it has got the registration. The presumption should be otherwise it is not registered. Therefore, we conclude that it cannot receive. So, it is not eligible to receive the foreign contribution. So, on the assumption the certificate has not been taken by the trust in Mumbai, it cannot receive for thing. If it has received, then it becomes invalid. That's how we will have to conclude.